This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Ballmer, and today I'm excited to welcome Professor J.W. Verret to the show. Now, Professor Verret teaches corporate securities law and financial accounting at George Mason Law School. Additionally, he's a published author, practicing attorney, and sought-after expert witness, specializing in securities and corporate litigation, forensic accounting, and fraud examination. Professor Verret holds a JD and master's from Harvard. Professor Verret, thank you so much for joining me here today on Engaging Experts.
Great to be here with you, Noah, at the roundtable.
Yeah, absolutely. Well, let's jump into it. So you've made a career in academia, but you continue to practice as an attorney and an expert witness. How do you find the time?
Well, to be honest, when I started in my 20s as an academic, my portfolio made sense. As I got older and my family grew, I have 4 boys at home.
Oh, wow.
I have a flexible career, but I have some obligations to meet, and this gives me the opportunity to do that. It's also true that practice and expert work makes me a better teacher. I'm able to be both a tenured academic who publishes in academic publications and academic articles that survive the rigors of tenure, but also are written with a design to being useful in corporate and securities law questions that are actively litigated in court. So I find that grounding in the academy, true grounding in the academy as a tenured expert, makes me a better expert. And my work as an expert in practice makes me a better teacher. So there's synergies all around.
There are synergies all around. Do you use any particular scheduling techniques? Are there calendar softwares or something that you like to use to keep your days organized?
I use Google Calendar, but when folks use Calendly, I respond to that. The world seems to be shifting in that direction a little bit, particularly in your area of the world.
Sure.
The Silicon Valley folks really love Calendly, but no, Google Calendar does a pretty good job of keeping me in line. And look, I have a lot of clients with different preferences. So some people are really into Teams. Some people are really into other ways of communicating. So I'm on a lot of platforms, and that's just part of, as an independent with a lot of affiliations and a lot of roles, you just have to be ready to have a lot of email addresses and a lot of platforms and check them all. So that's just part of the game here.
Be nimble. Good advice. So how did you first get started in expert witnessing? Did you get a call out of the blue? Is it something that you were looking for?
It was something that I was looking for. My mentors had done a good bit of that. My mentor was a guy named Professor Lucian Bebchuk at Harvard Law School, and he had done a good bit of that in his career. I was hoping it would grow, and it actually got an opportunity very early in my career. So I was 28 years old, first time I was an expert in a matter involving a pension funds lawsuit against the CEO of Sprint. So it was the deep end of the water here. The allegation was that the CEO wasn't straight with the world about his own personal tax problems as a result of some issues he got for putting his options package into a tax shelter that the IRS had deemed void, but that he still owed taxes on. So in other words, he had an options package that didn't incentivize him at all because it was worthless, but he still owed a lot of taxes, so he was personally bankrupt. Question is that material or not? So I took on the opportunity. I was very young. I still believe I was qualified, but I was very young. It was very early. I went through a 7-hour deposition with a lawyer from Cravath. It was trial by fire, but I survived it. The case settled, and I've just been going from there.
So as somebody who has been through law school myself, they don't prep you a whole lot on being an expert witness, what it's like from that side. You mentioned that you had some mentoring. Did you find that valuable? And what in particular did you take away from it? What would you recommend from newer expert witnesses vis-a-vis getting a mentor and making the best use of one?
Yeah, this is hard because most mentoring in the expert field comes from working at expert firms.
Sure.
There's not a lot of ways to get it otherwise. Experience is the best teacher, but that can be very dangerous in expert work because a couple of bad Dauberts and a couple of bad testimonies, and then your career's over. So making those mistakes earlier, very dangerous because once you get in a hot seat, you are making a record that exists forever. I was lucky that I had the opportunity to testify in Congress a number of times. This was right after the financial crisis and before the Dodd-Frank Act. So in a couple of years, I had an opportunity to testify in the House and the Senate about a dozen times about corporate governance and securities and accounting issues. And that gave me an opportunity to learn the discipline to learn disciplined communications, to learn that you, to some extent, take off your academic hat that explores a lot of different hypotheticals and is kind of willing to take any opinion and then debate it and then back away from the opinion you took to change your opinion. That sort of academic way of thinking. Instead, engaging in very, very, very disciplined communications where the members are very heavily prepped and they're looking to get a sound bite and they're looking to make you look ridiculous with a sound bite. And so being in that environment has translated a little bit to the expert environment. It was a good way to learn how to be very disciplined about exactly what you intend to say and to respond to a question with what you have decided you intend to say.
Oh, so it's easy. So new expert witnesses should just testify before Congress to get some experience in that.
It worked for me. It worked for me. I think for other experts out there, you just can't avoid working at an expert firm and backing up another expert as they and just kind of working through that apprentice system.
Speaking of firms, have expert witness referral services been a boon to you? Is that something that has helped you get work and improve your work?
Absolutely. Yes. Especially early on. I have my own firm, Veritas, and I have affiliation with you guys with the Expert Roundtable. And it's a great combination. I do my own marketing and I try to get myself out there. But I love it when I get a call from you guys, and it's always been a case that's very well curated and very well designed for where I would fit already. So a lot of that work is already done. So it's great.
Let's talk about those phone calls a little bit. You get a call from either the attorney or one of the attorney's representatives, maybe a paralegal. How do you vet that job in terms of A, are you the correct expert in terms of subject matter, and B, is it just something that's going to work? Are you going to click with this team? What's the calculus that goes into making that decision?
Yeah, I would say it's three things. First, am I an expert in the subject matter? Am I going to end up with, assume this goes, every attorney thinks everything's going to settle, but assume this goes all the way to trial. What's that Daubert look like? And I'm sitting in a Daubert chair for 3 hours, and what happens to me at the end of that? I don't want to try to take on something that's outside my range of expertise. So far, I went through one Daubert experience, got through it, and was named an expert in exactly what I was going to be an expert for. That's not to say it's career ending if you try for something outside your area, but that means that sort of sub area, that's going to be used against you, even for other areas where you do have the appropriate focus and expertise. So you want to be careful about that. The other thing you want to do is make sure that you agree with the position. I mean, look, I'm not going to get behind a position I don't agree with. I want to, and there's going to be uncertainty and unclear things, and that's not to say you need to believe the person is guilty or not guilty in a white collar criminal matter, or you need to believe that one side or the other should win. But for the particular issue, you have to you have to understand the particular issue you're being asked to testify about, and you have to agree with the position. You have to strongly agree with the position. It's better to let something go than pursue it if it's not the right fit. And then thirdly, professionalism. Am I going to have to hunt you down when the retainer is empty and it's time to replenish the retainer? If that's a part of the engagement, and that's usually a part of the engagement that I prefer. If that's where this is going, then I don't want to take that job either.
One of the most difficult things for newer expert witnesses is saying no, because they may not have as many opportunities as somebody with a long and storied career, such as yourself. When you were first getting started, did you turn down a significant number of potential engagements?
I actually erred on the side of turning down, and I probably turned down things that I could have pursued. Sometimes you wish you could go back to those. The other lesson I learned is that when you get the phone call, you need to respond right away within a few hours. Doesn't matter if you're on vacation, doesn't matter what. So I had an experience where there was an opportunity I really actually wanted. I didn't set my faculty voicemail up to auto forward to me, so I just wasn't in the office for a day or two. I missed an opportunity because someone called and then they called another expert a few hours later and then they picked that expert. So you better believe now, if you leave a message on my faculty voicemail, I'm going to get an email about it within a couple of minutes, and I'm going to respond to you in a couple of minutes, even if I'm at family dinner or whatever, and we're going to chat right away. So don't wait.
Absolutely. Okay, so you've taken an engagement, you've decided that you're the right fit, and then you meet the trial team. Have you worked on fairly extensive trial teams that might have multiple lawyers and multiple experts?
Sure. Yeah, I did that recently in a case called U.S. versus Sterling Off, which was a $300 million money laundering criminal case, and
Wow.
worked with other experts, worked with other lawyers. In some ways, it was heartbreaking because the defendant was ultimately found guilty in that matter. But in some ways, some parts of it where the lawyers rented a house in D.C. and the 3 or 4 lawyers and 2 or 3 experts all lived in that house. I happen to live in D.C. already, so I didn't get to stay in the frat house with them. But they had this sort of frat house for a month, and the lawyer's dog was there, and it was just like, 18 hours a day prep for a trial, or once the trial started, go to trial, go home, get a bite, and then we're prepping. So I spent a lot of time in that little frat house and made some bonds for life, some friendships for life as part of that experience.
And that's important, and it's something that I hear from newer expert witnesses. They're not exactly sure how to go about meeting other experts. Are there, besides being forced into those situations where you're on a team with other experts, what are some of the other ways that newer expert witnesses can just get some questions answered from other more experienced experts?
That's a hard question, because either you're in-house at one of the established firms or you're a lone wolf. I'm kind of a lone wolf. I look for opportunities to meet people at other academic conferences or professional conferences like American Bar Association, or some of the forensic accounting, like the ACFE. So in my field, yeah, I would say go to the ACFE meetings. If you're a forensic accountant in litigation, you'll find other experts there to chat with. Or if you're coming to it as a lawyer, which is a unique kind of expert that often doesn't get opportunities to be experts, but sometimes gets a very niche opportunity to be an expert, you'll find your tribe at the American Bar Association.
Do you find that as an attorney, it's the expectations are in some way different for you as an expert?
It's a different world. I One of the ways that I market myself, one of the great advantages of me that I think makes me unique from anyone else, is I am both at the same time a securities and corporate law professor and a forensic accountant, a recognized expert in forensic accounting. Um, and so I get 2 hats to wear. And it's kind of like if you've ever played a fantasy role playing game, sometimes you can be both a wizard and a warrior. It means you have maybe a little bit less of the attributes of each one, but you also can get synergies as being both.
So you
So I'm
multi-class.
Yeah, multi-class. So I'm a wizard and a warrior. What that means is when I'm sitting in the deposition chair, when I'm writing a report, I understand all the working pieces of the case pretty much around my report. I understand my piece as a forensic accountant or as an economist. Sometimes I wear that hat. I understand my piece and what I'm doing there, but I also understand all the working parts around that report without the attorneys needing to explain it to me. And when I'm sitting in the deposition chair and an attorney has a new trick they want to try, I usually have a pretty good sense of what they're trying to
Hmm.
get me to say that I don't believe, but they're trying to trick me into saying. It gives me a better instinct about that. So that's useful. And the hazard is just that, look, the fight always is that the other side will say, oh, you're trying to give an opinion as a lawyer, and that's for the court to say, and so we get to exclude it. In which case, I'm pretty well prepared to say, no, that issue is an issue of both accounting and economics, and it has implications for law. It's a multi specialty issue, and so I'm speaking to that question appropriately. I'm used to that, but that's the advantage, and you have to be prepared for the disadvantage if they try to disqualify everything you say on the basis of you being a lawyer. And of course, you just have to be prepared for that fight.
Right, right. I want to go back to that Dobert hearing that we were talking about before. That's definitely a stress point for newer expert witnesses. Can you describe that process a little bit, how it went, and any recommendations that you have for people who are about to go through their first one?
Yeah, this experience was in U.S. versus Sterling Off. This is a matter where it was high stakes because it was a criminal matter. At this point, after the trial, the government is seeking 30 years for Mr. Sterling Off. He alleged that he ran the largest Bitcoin mixer that mixed all the Bitcoin that came out of the Silk Road drug site. This was a $300
Wow.
million money laundering accusation. Yeah. I was there to provide expertise in a number of areas. So the Daubert hearing was 2 days. So I was in the chair for I don't know, 5 or 6 hours, getting grilled by an assistant U.S. attorney who really wanted a piece of me. And it was a good experience on the other end. It wasn't fun while it happened. And you get these panic moments in your head. One of the things I did was I focused on my breathing. That's what I do in every stressful situation. If you ever read about what the Navy SEALs do, the box breathing, where you inhale, keep it inhaled for a couple of seconds, and then exhale, keep it exhaled for a couple of seconds,
Hmm.
and then inhale, and you just practice that the whole time you're out there. It's going to provide you with tremendous advantage. It's going to relax your entire body, take down the temperature that opposing counsel is trying to bring up inside of you, and focus on what you need to say and what you need to do. So box breathing, look it up. I highly recommend it for stressful situations like depositions and testimony and cross-examination. So that helped me a lot with that experience. What would I do differently? Um, I would spend a lot more time with my expert credentials, have more references. It only came up later, 6 months, 12 months later, as the government tried to limit what I could say. They would often say, well, this wasn't properly noticed. I was relying on the lawyers to properly notice aspects of me, and I probably should have been doing more to help the lawyers when they were focused on a million other things, to say, look, you need to notice the government about the fact that I'm going to testify about this. For example, I did here's just one example. During my Daubert, I did not mention that I was going to conduct forensic interviews in prison of the defendant, but the assistant U.S. attorney asked me, "Have you conducted forensic interviews in prison?" And I said, "I just got on this case. I have not done that yet." And then I went ahead and did it. I would have thought that was sufficient notice to the government that I was going to do that, but the government raised their hands up and said, "Oh my goodness, we had no notice that it was happening." And the lawyer said, "What? You asked him if he had done that, and he said it was a good idea. So, and we also, before trial started, we noticed you about it." I said, "No, no, no, that wasn't enough time." And I didn't get to talk about the forensic interviews that I had conducted in prison because I should have thought that far ahead and thought that I needed to include it in my initial disclosure. I wish I had now.
Is that a failing of preparation? Is that something that your attorney should have had handled before you went into it? Foresaw that, or is that the sort of thing that experts need to be aware of going into the proceeding?
Well, I'm not going to fail the attorneys because they were drinking from a fire hose. They were writing motions that due the
Right.
next day, every day. It was a pro bono matter, so nobody got paid, and we were all there because we believed in the case.
Right.
So yeah, it's just I should have done more to think through what the attorneys need to do to help me and support me. And I should have what I should have done was just had a supplemental filing after the Daubert saying we're going to add to what he's going to testify about and specifically mention that item.
Sure. And speaking of proceedings where you're being impeached, you are a well-published author. You've written for several law journals, newspapers, etc. How do you keep track of all of that and avoid a situation where a judge or a panel or someone is trying to impeach you on something that you may have said 18 years ago that may or may not actually even be applicable, or maybe you've changed your mind on something? How do you keep track of everything that you've written or said on a matter?
That's interesting. I've always had a thought that would happen because I've written a lot of articles. It never really has for the academic articles. Maybe that's just the style I write,
Hmm.
or I think I do a good job of sticking to taking positions that are consistent with general topics I've written on. I did have the experience of my Twitter feed being thrown at me in this criminal case. I happened to take the position, my personal policy views, very critical of government surveillance of private financial information. And so this was also a case where the privacy was at issue. Should you have the right to have privacy in your use of Bitcoin? And was this defendant just using these privacy tools for his own personal privacy? That was part of what was issue, right? So the AUSA, and This is what you do when when they think they have a surprise gotcha moment. You just embrace it. You say, "Yep, absolutely right. You're absolutely right." So the AUSA says, "Did you tweet that financial surveillance is evil?" And I said, "Oh, counselor, that absolutely sounds like me. Yes, and it can be evil when the government abuses financial surveillance, like Russia, like Venezuela, like China has done, and like the U.S. has done in some instances." And I think he thought I would kind of shrink back in the chair, but I just grabbed it and jumped on it and used it as an opportunity to start talking about why I believe that, which helped the case. So he opened a door that he didn't realize that he didn't want to open. He said, "Your Honor, objection. He should just answer yes or no." By then, I'd already said my piece.
Right.
So the jury heard why I believe what I believe. So yeah, I tweet a lot. I try to think a little more about every tweet could be mentioned in court. But you just got to own it, and you just got to say, "Hey, you look at the jury and say, I fired off a stupid tweet. You guys ever done that? Right? Something like that. That
Become
happens."
relatable. Yeah, with social media, I guess that there's two ways that you could go about it. You can avoid using social media, at all, and not have really much of a public record of your personal views on anything, or as you say, you can kind of own it. So, that's a really interesting dichotomy. Besides Twitter, do you use other social media that anybody can go look up and see your views on any particular topic?
LinkedIn. I actually find LinkedIn is a great development tool for expert work, and I love LinkedIn. Look, at some point, somebody's going to pull up and some marketing that I do for myself and try to cheapen me.
Hmm.
In which case, I can say, everybody in business markets what they do. That doesn't mean I'm going to come here and make up something just to get some money from a single engagement. Because counsel, I think that the moment I get dinged in an opinion from a judge, that limits my engagements going forward for the rest of my career. My reputation is essentially, I've got the speech lined up for
Sure.
that cross examination.
For you mentioned marketing, and that's an interesting topic. I've run into expert witnesses who don't do any marketing, and I've run into expert witnesses who do quite a bit of different types of marketing. What have you found to be effective for your practice?
Docket monitoring and finding something that really is the perfect case for you. For me, it's a very limited set of things in that I really need to monitor. SEC enforcement cases, obviously. Docket monitoring, finding a position you can get behind based on what you can tell from the public filings, and then introduction to a conversation. And then in terms of generally getting on the phone with lawyers, one thing that always works is if you see something they've done or published, and the email starts with, "Hey, I read your article. It's great." And I'm always truthful about that. "I read your article. It's great," or "Congrats on the move to a different law firm.
Hmm.
By the way, while I have your attention, can I get you for 15 minutes to pitch you on your expert work?" They always read the congrats, because that's how human ego is. We're the same. I'm the same way. And then once I have their attention with the first paragraph, the second paragraph gives them a couple sentences about why it's worth their time to spend 15 minutes with me talking about Veritas Financial Analytics.
That's interesting. These kind of more guerrilla marketing tactics after a fashion. Um, Speaking of that sort of thing, has expert witnessing, you've been doing this for a while, has expert witnessing changed in any fundamental way since you first began, be it technology, technique, maybe going to settlements more often than they used to? What are the things that you've seen happen over the years?
I think with the technology available, data technology, the ability to just use Dropbox and Box and Stata and Excel and now AI enhanced versions of everything, the big firm advantage is eroding. And I think that boutique operators like me can go toe to toe with the big guys for a lot more than we could before. And I think that's the general trend going in that direction. That's not to say the big guys are going to learn how to harness that technology too.
Sure.
But I think the model of expert and then under them a legion of analysts that support them, that's going to die. In the same way that big law model is going to die. There'll always be superstars, but those superstars are going to be aided more and more by tech instead of by bodies, instead of by people. And that's the way it's headed. So that means that at least boutique like me can compete with the big guys.
You mentioned AI? Is AI to you playing field leveler, or does it introduce kind of noise into the system? Where do you stand on AI, just kind of generally as it pertains to expert witnessing, or even to being an attorney?
It's a useful supplement. It's an essential supplement. So I teach an AI-based legal writing class.
Oh,
Um, and I think you have to go into it with a philosophy that it is not there to replace anything that you've done before. You need to do your own writing first, so you don't limit your own creativity. And then this tool can enhance what you do. It's a tool, um, not a replacement. So if you're using it to enhance the efficiency or the reach of what you're already doing, that's the right way to approach it. If you're trying to be lazy and use it to replace your own original thinking, original work, you will fail, because at least for now, it's very obvious when you do something with it with a lazy use of an AI tool. It's very obvious. Whereas otherwise, if you give it 10,000 words of your own writing and say streamline this into 8,000 words, that's great. But that's really you. That's your thinking. That's just
right.
assisted a little bit by AI. Um, so use it in research. Use it to organize your own notes. Use it to edit your writing. But otherwise, do the bulk of it yourself and feed it. Feed it a lot. Feed it more words than it's spitting out. So if you want something 5,000 words, you need to give it 10,000 of your own words. That's when it's best. That's how I use it.
I wrote a recent article comparing different AI software as it pertains to being an expert witness, for instance, helping you with a report, to fairly mixed results. And one of the conclusions that I came to is that even when you do as you say, and it works properly, it is important to double check it and reread everything at the end. Don't trust it.
Oh yeah, yes, of
don't
course, yeah,
don't trust the output until you've read it.
yeah. Every word needs to be yours, and I think that in preparing for cross examination, you just I'm getting ahead to one of the questions I think you wanted to ask me, but
Let's talk about
it's
cross examination. Sure.
it's just I don't war game with other people because all of that's discoverable, so I don't want to do that.
Sure.
But the thing I do is just meditate, like meditate on every single sentence of your expert report, and just beware. Just sit. Don't just read it. Just set this sentence. Let me think. Let me give some meditation on this sentence alone. Why did I say this sentence? If I'm asked to defend this sentence, what would I say? And
Hmm.
then do that to the next sentence, and then do that to the next sentence. Because what you've written is like the Bible. So you have to be able to quote your own scripture, and every single phrase needs to stand on its own.
Are you ever given kind of a skeletal outline for a report from an attorney, or do you usually write everything whole cloth?
I write everything. I don't want. I would never take an attorney's, like if they gave me language and say use this. Attorney feedback in formatting is great, uh, because I start with creativity and coverage of the necessary issues, and that's the first draft. And if attorney wants to take a look at it, I say, look, my formatting's garbage. My sites are garbage right now. If you want to help with that, that's great. If you want an associate who can help with that, editing and formatting, that's fine. But just I've done the original thinking. Make sure the thinking is right now, and then I might get an RA to help me a little bit with the formatting, and or an AI tool to help me with the formatting. But no, if an attorney came to me and said, use this language in your report, I would say no, because when somebody asked me on the stand, were you told to use this language? And I have to say yes, I'm gonna look like an idiot. So there's no
Right.
way that's happening. That is not happening.
You mentioned formatting a couple times. How important is the presentation of the information, for an expert report?
Well, that's the final thing. And yeah, a presentation is important. It's sort of like, you cook the meat and you make sure the meat's cooked well, and you make sure the sides are cooked well. And then the last step is to put the little squiggly lines on the plate like the chefs do. I'm not saying skip that step. I'm just saying that's the last step in the process.
Sure. It kind of to me it seems like it's akin to demeanor in court. The content of what you say is important, but then the way that you present yourself. And I wanted to ask you, with technology increasing and people using a lot of things like Zoom and remote technology to even go into court, I've seen entire trials now can take place on Zoom. Is there a
Yeah.
difference in the way that you prepare or present yourself, or is demeanor on camera different than it is in the courtroom?
It sure feels different. So I recently did a deposition against the SEC, and I did part of the deposition in person. And you know how that goes. You get into a room, and maybe your own counsel is there, maybe not. Maybe they're there by Zoom. This one, the counsel who hired me was there by Zoom. So the SEC and CFTC lawyers was a joint case. We're all sitting there around the room, and they're all looking at me like I just got called to the principal's office, and it's a small room, it's claustrophobic, and would you like some water, professor? But they try to make it so that you have to ask me to go to the bathroom, professor, and you try to play the game of, you know what? I'm going to say when we go to the bathroom. I'm just going to go. Thanks, counsel. I'm in charge. There's little games,
Right.
versus the other half of the deposition was at home. So I'm in my basement. I'm with my dogs. I'm safe. It just feels different. And I don't get nervous anymore at depositions. I've done half dozen of them. And especially after that big criminal cross-examination, it's becoming a little bit old hat, but it still was just so much more relaxation. If you're opposing counsel, you definitely want to depose that witness in person if you can. It was a much better feeling to be at home with my dog sitting with me and just feeling kind of relaxed. Just have fun with it at that point.
Have you ever been in a situation where you've been remote in a jury trial?
No, not yet.
Okay. Speaking of juries, how do you go about connecting with them during your testimony?
Eye contact.
Okay.
Eye contact.
Do you ever use demonstratives, exhibits, charts, models, anything like that?
Yes, and the most of the prep time with the lawyers was just, let's see how much we can cut. So I started with the fat PowerPoints, and the lawyers are like, oh my God. And I was like, look, I just want to make sure I didn't lose anything important. They're like, all right, fine. So they just took just slice, cutting out everything you can from that thing. So there's like 10 words on each PowerPoint, and we got maybe 15 PowerPoints at most.
Mm-hmm.
And that's it. That's all you get. And a couple of graphs or charts if they're really self-explanatory and punchy. And that's it. Keep it simple. Keep it simple and lean. And if you want to talk, you can talk, but you don't want them spending a lot of time looking at it while you're talking.
Do you find that's that pictures are worth 1,000 words? Are demonstratives more effective than just talking to the jury?
Only if you only have a couple of them.
You don't want to overburden them with too long of a slideshow.
Absolutely.
I wanted to ask you if you've had maybe a case or two that have either reinforced or changed the way that you go about expert witnessing, kind of touchstone cases in your career as an expert witness.
Well, I've learned from other experts. One practice that I think is very useful is having your expert there while the opposing expert is being deposed. And so I've done that a few times, and it's very helpful because I can give you a lot of, you think you're the expert cross-examiner, but I can give you stuff that you don't know to ask about in real time. So I think that's helpful to do. And I've had an opportunity to learn from some good experts in matters like that. Of course, I can't mention them because of the confidentiality, but
Sure.
I've had an opportunity to watch some really good experts and see how effectively they can effective discipline. I think I'm disciplined, but I've seen people who are even more disciplined and who, in response to a reasonable hypothetical will say, I don't engage in hypotheticals. And we'll say that like 200 times in a row, which is hard to do when you're sitting in a chair, but I've seen that discipline. That you're there to speak to the report and not engage in hypotheticals that don't involve the facts of the report. Yeah, so that opportunity has been good. And the other just general advice I think is it is self-serving, but it is also true.
Sure.
That it's very useful for lawyers to have your experts in early. Have them in as kind of a consulting expert early. You have to be careful about using me as a consulting expert when I later become a testifying expert. But I can give you advice about discovery that's useful. That's not to say I'm going to use a bunch of hours on it, but I can give you some advice about what to ask for in discovery that you will have wished later that you asked for when we get to subsequent motion to dismiss and we get to expert testimony and stuff like that.
Absolutely. One thing I want to ask before we wrapped up, you had mentioned regarding billing running out of retainer. And that's interesting to me. I like hearing about the different methodologies that experts use in terms of billing. So I take it that you use some sort of a retainer mechanism. How do you set up your billing?
Well, if I know you and I've worked with you before, and your client is reputable and is a big public company, or you're with big law, and I know you and work with you before, I'm willing to be flexible. But if I don't know you, then I need an evergreen retainer, which means upfront retainer. I bill from the retainer, and when the retainer gets to zero, the invoices, the retainer gets filled up again. And if there's an outstanding invoice that's beyond the last retainer, that needs to be paid before anything happens. So I'm not going to sit in the chair. I'm not going to give you a report until you pay outstanding invoices and until you replenish the evergreen retainer. That protects you. That protects me. That limits compromising my independence through billing
Sure.
issues. And if you're not able to do that, then we have to part ways.
What do you find meaningful about being an expert witness?
It gives me a chance to do something real. And one of the frustrations with being an academic is sometimes it doesn't feel like what you're doing is real. It's just kind of mind games with jargon on a journal article. Not always really like that, but sometimes it feels like that. It gives me a chance to make my academic research meaningful, significant, impactful, and more informed, more well-informed than someone who only has the experience of reading other law review articles. I do that, and I actually sit in the chair in real disputes. So I understand how theory meets practice. And for me, it's the ability to honing the ability to move in and out of both worlds has taken a lot of time. It's been very hard. It's a challenge to do both at the same time, but I'm better off for being that challenge. I'm a better practitioner, better expert, better teacher and scholar for wearing all those different hats and trying to survive with all those different hats. And now that I'm coming into to mid career, midlife, I feel a strength in each of the things I do because of my abilities in the others.
Excellent. Professor Verret, thank you so much for joining me here today on Engaging Experts.
Thanks for having me, and thanks for working with me. I love you guys, love the roundtable, and you provide an essential expertise to lawyers who are panicked looking for an expert. You guys can steer them to me, and they'll be all set.
Absolutely. And thank you to our listeners, as always, for joining me for another episode of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.